Let's talk about labor law. Let's talk about the doctrine of waiver and quitclaims. So, the case of Rizal Commercial Banking Corporation versus Bithao. So, RCBC versus Bithao, which is 500 SCRA 119, citing the case of Periquet versus NLRC, will tell us this. Not all waivers and quitclaims are invalid as against public policy. If you've ever left a job, and it wasn't illegal in any way, like your contract ended or something, after the clearance, they'll have you sign a quitclaim. So not all waivers and quitclaims are going to be invalid for being against public policy, because not all of them are. If the agreement was voluntarily entered into and represents a reasonable settlement, then it would be binding on the parties and it may not later be disowned simply because of a change of mind. It is only when there is it is only when there is clear proof that the waiver was wrangled from an unsuspecting or gullible person, or the terms of settlement are unconscionable on its face. Let's say that again. Or they use the big words. It is only when there is clear proof that the waiver was wrangled from an unsuspecting or gullible person, or the terms of settlement are unconscionable on its face, that the law will step in to annul the questionable transaction. But where it is shown that the person making the waiver did so voluntarily with full understanding of what he was doing, and the consideration for the quitclaim is credible and reasonable, then the transaction must be recognized as a valid and binding undertaking. So, what is a legitimate waiver then? In the case of Magsalin versus National Organization of Working Men, hot. The National Organization of Working Men, legitimate waivers that represent a voluntary and reasonable settlement of a laborer's claim should be respected by the court as the law between the parties, because it's also just freedom to contract, right? Unless there was some sort of vitiation of consent, or the labor was gullible, unless there's some taking advantage of labor, wherein the constitutional protector to afford full protection, the constitutional protector, what did I just say? The constitutional mandate to afford full protection to labor would then kick in, right? Otherwise, it's just contract. The court will respect it because that quitclaim, the legitimate waiver, would be the law between the parties. In the case of People versus Donato, the court also said that a waiver is the relinquishment of a known right. And what do you have to do if you're going to relinquish your right? You have to know of the existence of the right. And you have to have the full intention to actually relinquish it, right? Waiver is the relinquishment of a known right. Voluntary choice is the essence of waiver. So for a waiver to be valid and effective, it has to be, in the first place, couched in clear and unequivocal terms which leave no doubt as to the intention of a person to give up a right or a benefit, or to waive that right or a benefit which otherwise would legally pertain to them. It may not be casually attributed to a person when the terms thereof do not explicitly and clearly evidence an intent to abandon a right vested in such person. So, we don't presume waivers exist. I mean, I have the right to, I don't know, have a family, but do I exercise that right? No. I have a dog. But it doesn't mean that the right doesn't exist, you know. Anyway, when such quitclaim was made voluntarily and there's no evidence that the employer was guilty of any fraud or intimidation, or as the court said in the previous case, if the waiver was wrangled from an unsuspecting or gullible person, then the legitimate waiver would represent a voluntary and reasonable settlement of the laborer's claims, and it should be so respected by the court as the law between the parties. Employer not guilty of any fraud, we got no intimidation going on, obtaining the waiver, then its validity must be upheld by the courts. Likewise, in the case of Acuna versus Court of Appeals, the court said, a quitclaim must be upheld if there is no disparity between the amount of the quitclaim and the actual amount due to the complainant under the law. So, we talked about when quitclaims can be valid, what is a valid waiver, what are legitimate waivers in the context of in the context of labor law, which is that it's a voluntary and reasonable settlement of a laborer's claims. Okay, so legitimate waiver for labor law is a voluntary and reasonable settlement of a laborer's claims. Okay, now the quit claim, if it's made voluntarily and there's no evidence that the employer was guilty of fraud or intimidation when they're obtaining the waiver. And what is a valid waiver? We talked about already. Relinquishment of a known right. Voluntary relinquishment of a known right. Anyway, so the quit claim then, we talk about labor then, it is upheld, or it's, we're going to say that, yeah, this is a valid quit claim. If the amount of the quit claim and the amount that the complainants are actually due under law is the same amount, we're going to uphold that quit claim. Because why would you have a problem? You're due 2 months. They give you 2 months in the quit claim, so you can't file anything after that. Bing, bam, boom, no problem, right? Okay, wait 1 second. Likewise, yeah, a quit claim must be upheld if there's no disparity between the amount of the quit claim and the amount actually due the complainant. So that's Acuna versus Court of Appeals. The requisites of a valid quit claim this is from case law now, okay? 4 requisites for a valid quit claim. First, the employee executes a deed of quit claim voluntarily, so voluntary execution by the employee of a deed of quit claim. Second, no fraud or deceit on the part of any of the parties, so no fraud or deceit. Easy. Third, the consideration for the quit claim is credible and reasonable. And going back to Acuna, the quit claim will be upheld if there's no disparity between the amount of the quit claim and the amount actually due the complainants under law. Fourth, the contract is not contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. One more time, the requisites for a valid quit claim are fourfold. First, the employee executes a deed of quit claim voluntarily. Second, there was no fraud or deceit on the part of any of the parties. Third, the consideration for the quit claim is credible and reasonable. And fourth, the contract is not contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. So, first requisite would talk about how a waiver is a voluntary relinquishment of a known right. Second one would talk about how there is not some wrangling from an unsuspecting or gullible person, or that the terms of the settlement are unconscionable on its face, right? So there should be no fraud or deceit on the part of the parties. And the consideration for the quit claim is credible and reasonable because a quit claim must be upheld if there is no disparity between the amount of the quit claim and the amount actually due to the complainant. Legitimate waivers represent a voluntary and reasonable settlement of laborers' claims, which should so be respected by the court as the law between the parties, which goes into the last one, which is that even though there's freedom to contract, that freedom is not absolute. The contract should not be contrary to law, public order, public policy, morals, good customs, and it also shouldn't be prejudicial to any third person, which has a right also recognized by law. Otherwise, all these things are there, quit claim is valid, and then that's going to be the law between the parties that the court will respect. Nice, this was a quick one. All right, bye.